finishing wire.
You are.
Oh, I didn't do that right, did I?
Get it. Okay.
It's a speech defect from Boston. Okay.
We'll forgive you. We've had it.
All right. Clerk 16, not the back door.
Oh, no, another four. Oh. Back, it goes way.
All right. Anyway, we discussed a lot before the recess. And where do we go from there?
Judge, the next two are breach of implied warranty instructions.
Right.
And Milwaukee didn't propose reading instruction or elements or, and I don't, we can argue about these, but I think maybe give them a chance to give us something in writing, what they think would be appropriate.
We're fine with that, Your Honor.
Where are we?
I think that's fair, right?
It's over 33, Your Honor.
Can I just clarify,
And I do understand you have a pending objection regarding
privity?
privity. And I'll take a closer look at
Okay.
that.
Fantastic, thank you.
I got you. Because I'll listen.
I don't need to say anything, just ask me questions when you want to.
Yeah, absolutely.
Judge, this is 33 concurrent costs, slightly modified of stock instructions. So I don't know what the objection is, but I think we definitely need a concurrent cause instruction in this case because for the reasons Mr. Rasmussen keeps bringing up, we have a water meter, so there's got to be something.
All right.
I don't have a problem with this one. We would have done, I think the modification is fine because the 4.05 instruction in the 1986 book speaks of it with regard to negligent conduct of two or more persons.
That's exactly what we modified.
Exactly, and I think that needed to be modified, and I don't disagree with the plaintiffs on that. And I'm sorry if I didn't make that clear before, but that was the concern that I had. The 405 does not, it shouldn't be here unless it is modified.
So this is okay?
Milwaukee has no objection.
We have no objection.
All right, so that's taken care of.
All right, this is 34 product strippers are automatically liable for breach of code failure or breach coverage, regardless of whether the distributor is also the manufacturing product. So I don't know if we want to kick this one or what we want to do. I don't care one way or the other.
I think we need to kick it until we know what's going on. If that's okay.
Let's kick it to the breach.
All right, so this is what we're gonna do. I just wanna make sure it's right. I just wanna make a few notes real quick. So as far as 31,
31, 32, and 34.
right, so I wanna make sure I have those. So now we're at 35, is that correct?
That's correct.
That's where we started with.
Which is which we started with. I think we're done. Or I know that Ms. Lowell has another one that she was submitting.
So when we say we're done, we really, except for.
Instructions.
Yes,
Except for the 3 breach.
And there's a few pending issues that we'll need to meet and confer on.
Yes.
But other than those 3, I think we can get a close to complete set after we meet and confer and then handle the 3 remaining and try to close them out. But that's what the plan is proposed. I think that takes care of all the Hannas and Real Waters. I know Milwaukee had another 1 or 2 that are still out there.
Yeah, we did provide everyone with our proposed instructions last Monday. I don't have any extra copies today.
People can finish.
I can give you.
You know what we can do? How about this? Maybe I have them.
That's your record.
So, Your Honor, I think one of them we already discussed, it's the proximate cause, so we already did legal cause.
Right.
And we.
And that's on page 3, right?
That's correct.
Yes.
Ma'am, I do have it.
Okay, great. So, and I think, have you already ruled on the misuse, 7.07?
7.07.
I thought we did.
That's fine, I thought you did
I
too.
thought you did too, but doesn't it also have a little bit to do with this new cause of action? Could have an implication on the breach. But maybe not.
Well, I mean, and I don't mind saying this, I mean, I understand product misuse, but,
I think Mr.
There's no evidence
Rasmussen's
that-
point's covered by causation. There's a separate causation instruction he skipped over. I think that's what he's referring to.
Yes.
is that right? So, let's go to that.
No, those were the two we were gonna save so we could get.
Okay.
Milwaukee's.
That's right.
I just don't wanna overlook anything.
So the only thing that's left is on page 4, and that is, it's from the 1986 instructions, but we redrafted it. We added in hydrazine and things like that. My main concern is the original instructions are written in a kind of double negative that I think is confusing.
Yeah, Judge, this is kind of an
And at this time,
Go ahead, sorry.
At this time, I don't believe there are any instructions on superseding cause in front of the jury. It is an affirmative defense that we pled.
Yeah, Judge, gets right back to the foreseeable misuse issue we were talking about yesterday, I believe. So once it's a foreseeable use, which it is, making alcohol, using the ore meter, measuring negative ore when you're making alcohol in the water. Once it's a foreseeable misuse, it cannot be an intervening superseding cause. And once it's a foreseeable misuse, or misuse for that matter, you don't get to argue intervening superseding cause.
I would disagree with that, just because, I mean, we're already talking about two causes, like two concurring causes. It's possible that one is real water, one is the defect in the mirror. Our theory of the case, defect in the meter. Our theory of the case is that real water made hydrazine, and without the meter doing anything improper, the hydrazine poisoned people, and the meter had nothing to do with it. Sorry,
No, I'm listening, ma'am, I'm listening, I'm listening and while
so
you're
I don't
talking,
think that's
okay.
the same, I'm sorry, I don't think that's the same as foreseeable misuse. It's an action of a third party that intervenes in the chain of causation and cuts it off.
Yeah, Judge, I think they actually have the key language cited right here in 17 through 20. And again, the Price versus Blaine case, that was the case where the person was going to a political event. He was wearing the big George Bush caricature mask, and the guy come up behind him, I guess he was probably a Democrat, pushed him and tipped him over. And so the argument that was made by the manufacturing company that made the caricature mask is that, yeah, this is a tip-over case, but we couldn't foresee people would push us from behind. Okay, so that was the issue, is all foreseeability. If you take a look at the language here, the question is, in light of the manner and extent of the injury attributable to product defect, thus focusing on whether the harm, in that case it was pushing over the person, however you did it, you focus on the harm, not the act that causes the harm, whether the harm is of a kind and degree that is so far beyond the risk foreseeable to the manufacturer that the law would deem it unfair. Okay, it's all foreseeability. So in this case, is it unforeseeable that someone would use the MW 500 quart meter to make an alkaline water product? answer is no. And they can argue, well, maybe it's unforeseeable that they would use it to add or subtract components of the product. I think that's pretty foreseeable too, Your Honor. So I don't think there's any argument to be had that this is an unforeseeable misuse. And it has to focus on the meter, not on the event. It never focuses on the event. Because if you focused on the event, like the George Bush example, you know, that was the whole manufacturing argument, that they could perceive that some criminal, because he was convicted of assault and battery, some criminal would come in and push someone. It's not the act that causes the event, it's the harm. In that case, the harm was the tip over. So in this case, the harm is that somehow or another it would cause some danger in the water. And I don't know how they can argue that, because we popped up some of their product literature that said you should use these meters specifically to avoid bad quality of the water. So they knew about it. But in any event, the general risk here is not unforeseeable. That's why I don't think this instruction is appropriate.
We disagree.
Just for the record, Real Water also objects to this instruction, and not to go on a tangent, we also note there's no cross-claim from Milwaukee or Hanna against Real Water, and this instruction tends to imply that and tends to open the door for further attacks by Hanna and Milwaukee and Real Water, which are, as you know, we've objected to and believe they're inappropriate.
And I would say Dr. Malkin testified that Real Water is unique, and that, you know, the jury doesn't need to be worried that maybe the people who are making their alkaline water, other brands, are, you know, making hydrazine and putting it in bottles that they're consuming. He said, no, that's not happening. And you know, the question is, was Real Water's manufacturing process highly extraordinary? And I would, on any other case, I would say, like, okay, I don't think I can prove that, but I think it's possible that the evidence here could lead a jury to come to that conclusion.
Judge, look what it says. 1, 2, and 3 are all reasonable. And it even says negligent on subpart 3. So my product liability claim against the meter defendant is defeated if Real Water was negligent? How could that be, Your Honor? I mean, that is making negligence a defense to a product liability claim.
But
how does that give maximum protection to the consumer? That's why the real analysis is what I've just said in Price versus Blaine, which they cite, which is foreseeability. Is it so unforeseeable that this could be an intervening, superseding cause? And where they knew that this was the usage of the meter, I don't see how that could possibly be missed.
Your Honor, I want to make sure we step back and don't lose sight of the big picture here. Because what
I don't lose sight of the big picture.
we.
Because here's my point. I mean, when it comes to foreseeability, you don't have to foresee the exact nature of the harm. Just that potentially a harm could occur, right?
Exactly.
I mean,
right.
and that's why I come back to, you know, I don't think I'm missing anything here. And here's the point. Yes, you can't, you know, and I've said this ad nauseum, but the thrust and focus is on the product, right?
Right.
And whether the product is in a defective condition, unreasonably dangerous, pursuant to the restatement of torts 402A. We all get that, right? We got manufacturing defects, we have a design defects, and this happens to be a warranty defect case. I have testimony in the case that you know what? We knew 30% of all of all purchases of the, is it MW500 warp meter was being utilized for Kangen type negative warp reading waters, period, right? And so there's no misuse of the product, period. And here's where the allegation is, and this is where the product's liability is an issue that has to be decided from a jury's perspective. They gotta look at the warning that's contained in the manual and all the other parts. You know, there's a little card and so on and so on. And they have to make a determination whether that's adequate. That's the case. In its essence. Right? Am I missing anything?
And it would have been acted upon.
Yeah, I agree with that. that's all.
I think that one of our defenses that we've raised several times is that it was not foreseeable to the meter company that a bottled water company or anyone doing water is going to put hydrogen in it. Unintended or intended.
But, wait, well, here's the thing.
Hydrogen in the water.
And they didn't put it in there, apparently it was a byproduct of the process.
And that's why I said unintended.
But here's the point, though. You don't have to foresee the exact nature of the harm.
I understand.
That's what the law says, right, on foreseeability.
We didn't also foresee that there would be people that don't know anything about safe laboratory practices as pursuant to our warnings using our meter.
Then you shouldn't have sold it to real water.
Okay.
I mean, that's the bottom line.
This is the large
Yeah,
ocean.
I mean,
That's the swimming pool.
if that's the case,
Right.
they have certain types of instruments and machines that are sold only to clinics, right? And so if that's a really valid defense, you should not have sold it to a water company.
And they knew they were selling it to real water, there's
Yeah.
emails going back and forth.
Right. I mean, the first question should be a checklist. What does that box say anyway, by the way? I just want to make sure. That little thing.
Knowledgeable and scientific.
You wanna see it?
Yeah, well, I mean, this is just for purposes of clarity. And my point is, and if this was the position the defendant's taking in this case, let me see this real quick. It says, the enclosed product is intended for use by persons knowledgeable in safe laboratory practices. Well, if that was gonna be used as a defense, it should have been sold only to labs, right?
No, people that are knowledgeable with labs.
Yeah, well, I mean, I would anticipate there's probably certain types of specialty machines that aren't sold to the general public.
Well, we just yesterday talked about selling it for fish and
Yeah,
swimming
aquariums.
pools and
Or
aquariums.
swimming pools. And that's a fact, I mean, he said that. Right, and he gave a good example of his girlfriend, and she had a green pool, and he took it over to help.
He dug the hole himself. in Rhode Island. It was amazing.
But I mean, and so, and that's kind of my point, if we're talking about, I don't see where there's foreseeable misuse, you know, and I understand specifically what that is. You know, misuse of a product, and you see that sometimes, there's no question about it.
Your Honor, just to be
Go ahead,
clear, we're not asking for an instruction on misuse. We're asking for an instruction on superseding cause. The case cited by plaintiff, Price versus Feinberg, it discusses the application of, you know, this was a motion on summary judgment, saying there was a superseding cause, the lower court found there was and the Supreme Court sent it back saying, no, this is an issue for the jury. The jury needs to decide whether there was a superseding cause in this product's liability case, which is exactly what we have here. And if Your Honor believes there's no evidence, then, you know, that's fine, but it's our affirmative defense, and we have a right to a jury instruction.
And here's my point, ma'am, what facts would support giving a superseding causation instruction?
Highly.
Under the facts of this case.
I think any evidence showing that real water behavior was highly extraordinary or extraordinarily negligent. And, you know, I understand Mr. Odou doesn't like that, but, you know, I mean, do you want to leave the jury with the impression that this is a normal way to make food? John Marlowe, who flunked chemistry, comes up with a product and goes to, you know, someone who bankrolls it, and no one ever does any testing to make sure there's nothing in the product. That is not how food is made in America. It's highly extraordinary.
Show my closing statement.
And I understand that, but, you know, I mean, so he's gonna make that statement, and I can't argue there was a superseding cause? I mean, that would be prejudicial to my client.
Well, here's the point, and I think you're missing one of the links, because the plaintiff has taken a position that the reason why your client is responsible under the facts of this case that if they would have given proper instructions and warnings pertaining to the MW 500 ORP meter and how to use it, and warned about certain precautions they should take, that this whole event would have never happened.
But hydrazine would still have been in.
I understand that, but for example, and we don't know this, but the allegation is essentially this, that if there would have been proper instructions as to conditioning of the ORP meter, right? I got that right. Proper instructions on the conditioning of the ORP meter, so it would give accurate readings, this would not have happened.
So,
Am I missing something?
Yes,
Well, I mean, but that's the allegation.
I know that, but
so actually plaintiffs are arguing that a little bit of hydrazine in the water is okay.
No, they're not arguing that at all. They're arguing that the failure to give proper warnings vis-a-vis the product's liability case resulted in this calamity that occurred.
But even if the warnings had been, if the meter had performed perfectly, would there still have been hydrazine in the water?
If there would have been proper warnings as far as the utilization of the ORP meter, right, then maybe this would not have happened, first. Number two, if there would have been proper warnings regarding the usage of the ORP meter, maybe there would not be a basis for a product's liability based upon failure to warn. I can't say it any better than that. That's what the case is about. And I know you might be chagrined, but maybe you should understand that's what the case is about, sir.
we understand. I'm sorry, you're all right, and
I'm just telling you, that's what the case, there's nothing, this is pretty straightforward tort law here, right? I'm just saying it, there should be no surprise here.
No, Your Honor, I'm actually criticizing myself, because if that's what the court thinks, I think I haven't done a good enough job.
Well, I'm just saying, that that's the essence of the case.
Like I said at the very beginning of the case, it's hard for jurors to understand product liability law. Sometimes it's hard for defense attorneys to understand product liability law.
I appreciate that criticism, and I'll take that.
Well, I'm not criticizing anybody. I'm just saying, I mean, this case, like any case, was randomly assigned to me, right? But I do think I have a fairly sufficient foundation on products liability law. And this one appears to me to be fairly straightforward as far as what the theories of liability are in this case, right? And ultimately, the jury is going to have to decide the adequacy of the warnings. I don't do that. But here's the point. I have to make sure the jury instructions correctly give the jury a roadmap and how to utilize the instructions on the law during deliberations. Nothing more, nothing less. And one thing I think I do a little bit differently than some trial judges, when I start out voir dire, what's the one concern I have? Can you follow the instructions of the court on the law? And do they understand what the instructions are? Because, you know what, if you're just talking in generic sense, jury instructions, they don't know what that means. But this jury knows what it means. Right?
Hopefully.
Hopefully.
Find out pretty soon.
So circling back, I'll just say, I'm gonna attack it straight on. The facts of this case do not support a superseding causation instruction. I understand there's hydrazine, but understand from a foreseeability perspective, you don't have to foresee the exact nature of them, only that harm can occur. That's what the law says. And that part of it, it's been saying that probably, I guess, Professor Prosser, going back close to 100 years, I'm not sure, but I think the law is really settled in that area. Let's go to the next one.
I think that takes us to the
Yeah,
verdict form.
I think that takes us to the verdict form, Your Honor.
Judge, do you have the verdict form?
Your Honor, we have some as well. I'd like to go ahead and make sure, I think I gave mine to the plaintiff's counsel, I have extra copies. Thank you.
We haven't seen it yet, but do you have that
I
correct?
thought I gave one, but I handed over Hannah stuff, but if you don't, it's
Your Honor, do you have a copy of plaintiff's verdict?
I have a copy, do I have these? No, we don't. Tori tells me no, so we don't.
part of mine then.
Okay.
Oh, Scott, I'm sorry, I thought you were giving a copy to the judge.
I will do so. I
Are you
will,
giving
I
a
promise.
copy? That copy?
I will give him this copy that you just handed me. Your Honor, may I approach?
Of course.
This is the plaintiffs.
All right.
And
thank you, sir.
Mr. Pepperman asked me to bring that to you. This is our questions for the jury.
So these would be the special derivatives?
Yes, Your Honor, I have provided those. This is our verdict forms. We broke these down for each one of the plaintiffs in the case. In other words, each plaintiff would get their own verdict form. So there's two of them, there's Mr. Felsky, and they're pretty much very similar. So they're not, here's Mr. Orion Gallagher.
And is there a specific role to that verdict form?
There is for Ms. Ryerson. And if I did it wrong, we certainly can change that, and I probably do need to change that with Mr. Haley. And I'll give these to, there's Gallagher, Arnone, Belsky. We have one for each one of your clients.
This is Milwaukee, that's why.
Oh, that's the verdict form, the special documents.
More? You want a form for each client?
I do.
So,
You guys can challenge that. There's one for Ms. Ryerson. I'll find it and get it back to you. It's still in my thing.
so Scott, just so we understand, there's 2 forms per planet? There's one.
So this is just one?
One of these, and then one for each.
One for each, yes.
Okay, okay.
They're very similar. But since we believe that there could be different, each plaintiff has their own numbers, dealing with medical costs and things like that. And a separate verdict form for each one of them was appropriate.
Okay.
Okay?
And okay.
We have one for Milwaukee, we have one for Real Water, and we have one for Hanna Instruments.
So, in Rockers?
No, the verdict form, the actual, here's the amounts.
Okay, okay.
And This brings to mind a situation I had personally where I prepared a verdict form for the Jim Grant case. And I was assigned to do that by the committee. And I prepared a verdict form, and we had, the hotel and a bunch of people. And so I prepared a verdict form that was actually even more complex than what Mr. Rasmussen has just handed to me, and I was all proud of myself. Then we had a committee meeting where I trotted out my early work product, and all the committee members looked at it, and, Mr. Gallagher kind of looked at it, and he's giving me the eye like he used to do.
Oh, yeah, he did.
And then Mr. Valli, he had no restraint, of course, so he said, "Who the hell prepared this defense verdict form?" I said, "I did." And he said, no, you got this all wrong. He said, "If it takes longer to fill out a verdict form than it does to order sushi at a restaurant, you've done something wrong." And his point was that you're giving them all these complicated jury instructions. You shouldn't have a verdict form that's trying to trip the jury up so you can do a retrial. He said you should make it as simple as possible. recognizing that you have to have various elements resolved by the jury. And I think this verdict form that we've designed is kind of simple, and it does satisfy all the elements. But, you know, this one I think is not, Mr. Belli wouldn't like it. It fails the Belli test, Your Honor.
Okay.
Do you have one, Joe, or you?
I'm still trying to understand how this goes together. I'm sorry.
I think our verdict form does incorporate some of the things Mr. Rasmussen is attempting to accomplish in a different way. So maybe we can combine it or, you know, change some language or something. If I can explain ours. So questions 1 through 7, remember this was prepared prior to the time period that Will Water stipulated liability prior to the trial of this case. So 1 through 7, I don't know that we need anymore. Mr. Odou suggested maybe we don't need those and we can put something else in there.
Yeah, I have a
I'm fine with
suggestion.
that. Go ahead.
I have a suggestion on what to put instead of 1 through 7. Definities, DefinityLifestyles.com, Inc., DBA Real Water, and Real Water Inc. have admitted liability and causation. Please go to question number 2.
Yeah, I'm fine with that. If everybody else is fine with that, sure. Striking's 1 through 7.
So you're gonna strike 1 through 7?
Well, Mr. Odou is proposing that, and I said I'm fine with that. If you want to keep it, tell me why.
Milwaukee has no
Talk about
objection.
I think the problem with 1 through 7 is it makes it unclear what the jury is finding, since Real Water has admitted responsibility.
Right.
It makes it sound like,
The leader defense haven't really,
and they haven't.
they haven't contested, I mean, they've said on the record over and over again that they haven't really thought the river into the case, so.
Well, can we just change the question for each one? This is because Real Water has admitted that drinking real water was a substantial cause of Orion Gallagher. Do you agree with that? Yes, no, or something like that. I don't, the reason is, the only reason I say that, and maybe I'm still being confusing, but I'd like to have on the record, on the verdict, that the jury has agreed. Yeah, with the admittance.
That they admitted.
That they've admitted, yes, and the jury, yep.
That's what Joel
Say the
suggested.
language again, Joel.
So the language that I proposed, and there's a Ryan Gallagher problem with that, the language I proposed was defendants, AffinityLifestyles.com, Inc., DBA Real Water, LLC, Real Water Inc., have admitted liability and causation. Please go to question number 2, and then question 8 becomes question number 2.
I'm fine with that, but I know there's a couple of spots that are difficult because of
That's okay.
Ryan Gallagher and Keith Haley, right? Is that what you're gonna talk about?
Well, I have a solution. When we go through it, we'll see what I did on that. So we could start 2 on the adequate warning. All right. So 8 becomes 2. All right, now 8, I tried it 2 different ways. Well, I tried it a couple different ways. One way was I said, did Milwaukee provide an adequate warning? And then I had a second one for Hanna, did Hanna do? Then I had, did Hanna/Milwaukee? The problem I had with giving both a separate one for Milwaukee and Hanna is that it should be the same answer for both. You know, if there, you can't have a yes on one and a no on the other, right? I mean, either the warning's adequate or not because they're distributors. They've admitted they're distributors. So I don't mind saying Hanna/Milwaukee, but I don't think we should have 2 questions. See what I'm saying?
I do.
Okay. So I don't care if we just say Milwaukee.
And their liability is derivative as.
Right, yeah, that's, so we can either say Milwaukee, or we could say probably Milwaukee/Hanna would probably be a better way to do it.
That's what I suggested.
But, yeah, that's what Teddy suggested, but I don't care. I just think it should be 1 question.
Sorry, Your Honor, I didn't hear all of that just because there was,
I
this
thought-
phone call was coming in.
Okay,
I apologize.
I think it should be 1 question, but I don't care if we say, did Milwaukee Instruments/Hanna Instruments fail to provide? Or if we just say, did Milwaukee with the understanding of this derivative? I don't care which way we do it.
Okay, I mean,
I think you should do it, and I agree with Mr. Odou on this, I really do. You have to make these instructions and verdict forms as simple as possible. And because what can happen is the jury can speculate. And they can, you know, and sometimes they'll go off on tangents while they're deliberating. And so you wanna make sure they understand clearly what their charge is when they deliberate. And here's my point, I'm looking here, and from a confusion perspective, it seems to me to be really clear, and we don't have to talk about which derivative, did Milwaukee / Hanna fail to provide an adequate warning? Right, I mean,
That's fine with me, if it's fine with Mr. Rasmussen.
Mr. Odou, what do you think?
Yeah, I don't have,
I actually don't have a problem with that. I think the word Hanna, I'm thinking about, I don't want to have this as a reason to be able to appeal this. So if we want to say Hanna and Milwaukee, if somewhere's in there, we say maybe a footnote, Hanna equals Hanna Instruments, Inc., a Rhode Island corporation, Milwaukee equals, no?
No, and well, here's the reason for it, it's getting really complex, that's the only reason.
I'm not trying to.
No, I understand that,
I'm just
but-
trying to make sure I've identified the party by the party, because I don't want this to be used as, oh, this will also now include every Hanna entity that ever exists.
What?
No, it's just the ones on the
what
complaint.
in-
So long as it's just the ones with the complaint, I'm good with that.
Yeah,
You
that's all.
told me what
Defendants,
Mr. Gallagher and
yeah,
Mr.
and
Bell I didn't like about what I did, you know? I made it too legalistic and complex.
Right. I mean, we can have, if that's the concern, I mean. the
It is for punitives.
Well, punitives are different, but my point is this, and understand this, did Hanna Milwaukee fail to provide adequate warnings?
Well, they're defendant too. Okay. I don't mind putting the whole name of the defendant.
No, you're right, it's long, I get that, I don't want it to
Jury
be,
knows who's who.
yeah.
Yeah.
I don't even mind saying Hanna Instruments, Inc. and Milwaukee Instruments, Inc. Maybe we just say that, I don't know.
Say that, I can say that.
We could say in the jury instructions too. Real Water, Inc. and Affinity Lifestyles Inc., Hanna and Milwaukee is Hanna Instruments Inc. and Milwaukee.
Oh,
That's probably not a bad idea, because there hasn't been any testimony about what affinity is really.
Yeah.
That, we haven't really touched that. Have we? No, is that, no one's explained that, haven't
I've been putting like the words DBA, because that's all I could figure it out for.
we? I'll just be saying that's.
I think the problem is mirroring the complaint. And if you wanna say real water,
Well, I think Eric's saying, let's have a preparatory instruction saying real water's full name is blah, 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 Milwaukee's full name is blah, 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 blah.
yeah, you do that in a jury instruction rather than a verdict?
Yeah.
Okay.
Yeah, okay.
Yeah, I don't have a problem with that. We agree.
All right, Judge, so that takes care of 2. So 9, which would be 3. So here's what I was trying to accomplish there. I was trying to, maybe I'm overly sensitive to this issue because this was one of the issues in Kiamani. The court said, well, where is it in the jury instruction and verdict form do you have causation? Okay, that was the whole argument on appeal. And the holding was that if you had it in the jury instruction, you didn't have to repeat it in the verdict form. That was the holding of the case. Despite that holding, what we've done is we've added a substantial factor to cost for each one of the plaintiffs. And the reason we're doing that is so there's no argument like we had in Kiamani that there wasn't a causation determination as to each and every plaintiff. And so Mr. Rasmussen has done that a little differently by having separate verdict forms with the causation element for each plaintiff. I think it's better doing it this way, because they're all there.
Yeah, I don't disagree with you.
Okay, good. So, having said that, I think it's fine as is.
And number 10 and 11, I think, are still in dispute. Until the later
10,
court.
whether we give them, yeah, but I mean.
Well, here's my point, I just have one, we're on number 4, I guess is 4 now, which would be 11, I mean, 10, and number 5, which is 11. There's 2 things I just want to do, and I'll tell you my final on that. Proceed like this is what it is, but, ma'am, there was, you had, what section, let me move this out of the way, because I wanted to get to this, because I want to attack it head on. you cited the Nevada statute you wanted me to look at for privity, and I'll come back to Mr. Kemp because he cited the case. I just want to take one last look at that.
NRS 104, 2318.
Okay. And Mr. Kemp, I know you cited the case for me.
That's Mahosco, Your Honor. And that's why I just put Milwaukee on 4, because I think Mr. Rasmussen would have a credible argument that the breach of implied warranty doesn't go upstream to his position because he didn't deal with.
I understand.
Yeah, I mean, that's the argument I expected to hear. But, so anyway, we put Milwaukee in there.
Then if that's the case, ma'am, do you still have a bone? You understand where I'm going, right? If they're not going upstream,
Okay, so now is the breach of implied warranty claim only against Milwaukee?
that's what it sounds like.
That's what I think the verdict form should say, Your Honor, because to be honest, I think Mr. Rasmussen might have the better argument against me on that one.
Okay, then I would still like to reserve until we work on the jury instructions for implied
I understand.
fitness.
That's one I don't need that.
And Your Honor, I think Mr. Kemp's right, but I would like to take one other look at that, because I have a feeling that there might be something that I've seen before, but, so just to, for now, that's fine, but I do want to take a second look, just so it's not as a,
You want to make sure Mr. Kemp's right, is that it, sir?
yeah, I want to make sure I'm
See what I have to go through, Your Honor. How many years will it take, right?
Right. Ma'am, we'll reserve that.
Okay, and we do also need kind of to figure out whether the plaintiffs are third-party beneficiaries under NRS 104, 2318.
I understand.
Okay. And then 5, the former, was that 11?
Yeah.
Okay, yeah, so 5 would be the same concept on causation for each one of the plaintiffs, but this time it's keyed into the warranty.
I'm sorry, Will, which one are you looking at? 5?
So 5, yeah, so number 11 becomes 5, so that's the question on page 3, right next to 19 and 20.
Sorry about that, thank you.
Yeah, that comes 5, and so that's just throwing a causation inquiry for each plaintiff. Again, like I said, Judge, I don't think we have to do this. I think it's covered by the jury instructions, but I think if I'm gonna go on appeal, I'd rather have something like this in my back pocket.
Any objection from the defense perspective? I think you'd want it too, right?
Yeah, I'm just trying to sort it out, Your Honor.
I'm not objecting to that, I just,
She's not waiving her overall objection, remember, she still wants to argue.
I understand.
I don't know what the jury instructions say for this. So.
No, ma'am, I understand.
All right.
I agree.
Okay.
Judge, then 12 through 23, which we have to change the numbers, of course. It's just the damages number for each plaintiff. And what we have done is we just put in for what we think is going to be, the issue. We are assuming that the summary judgment has resolved the hospital bill, so we don't have to put a line for that. We are assuming that we're going to come to some kind of stipulation on the futures, so we need to put in line for that. So all we put in was what we understand to be the recoverable elements for each plaintiff. And we said exactly what they are. I think we actually left off just figuring with Kathy Ryerson that,
So the first problem we have is hopefully really easy to resolve, or maybe not. The first 4,
yeah,
We have the
that's
sum.
my first problem, Judge.
so you got plans for
So,
that?
yeah, well, okay, so I approached it 2 or 3 different ways, and one way I was doing it, I was saying, if you find against Milwaukee and Hanna,
Right.
continue with 12, 13, 14, 15. I just thought that was kind of confusing, you know? I mean, I thought it was better just to, even if they're, let's say there's one of two things gonna happen, okay? One, they're gonna find against Milwaukee and or Hanna. Two, they're not, right?
Right.
So if they go on and they get a damages figure for Gallagher and you're not responsible for it, you know, does that really hurt you? I just thought the risk of confusion, because, and I'll show you the previous one we had.
Yeah, I know it's a problem.
See, the problem we had is, if you find against Milwaukee on question 8A, fill in, so
Right.
that's how we started it, and it just seemed like a real cumbersome way to do it. I mean, we can go back to that, but I just thought that, and if I didn't do it that way, I would have had to break them up, kind of like Scott's was, you know, just break them all up. So I thought it was better just to ask the question and, you know.
I guess I have two concerns. I mean, obviously, if we have the dismissal on file by the time this case goes to the jury, my concern is less.
But I think we've already put on the record.
And we have.
Okay.
We have. And the second piece of that is, we don't know what appeals will be taken from this case by anybody. And if the jury makes a finding that is, you know, somebody wants to argue is binding on real water, that's a problem. You know, they're gonna look at the verdict and they're gonna go, oh, well, there was this finding of this dollar amount for the Gallagher family as an example. That just seems like problematic, because now there's a jury verdict technically against real water, even though we know it has been dismissed by the time the jury renders the verdict. So I'm not comfortable with that. I'm open to suggestions on how to resolve that.
Well, the other problem I was trying to duck is we're not supposed to tell them you settled
We
those
are
two
not, I
cases.
agree.
Because if we tell them you settled those two cases, then they're gonna wonder, well, why didn't they settle the other 5?
That's
And
right.
So, you know, and they, you know, they like babies, they hate, you know,
Right.
they like babies, they hate dead people, you know, it just goes to a bad area.
It's a problematic issue, I agree.
Yeah, so that's why I did it the way I did it. I mean, after going through, you know, I put a lot of thought in this, Your Honor. And so I tried it that way, I tried it the other way. I just, at the end of the day, I thought this was the best way to go.
The concern that I have, the prejudice that comes here, is that a jury could come in and say, we really wanted to hit real water,
Right.
and if,
Or vice
or
versa.
vice versa, they really want to hit Hanna, I don't care which way, but if they don't know that they're gone with regard to these two specific plaintiffs, is that prejudice on me? In other words, if they really want to hit real water, then I'm gonna get hit with pain and suffering, and it would be a lot more, but they'd say, you know, pain and suffering on Hanna is this. Instead, for whatever reason, I don't know, I'm not the fact finder. They could say whatever they want to, but they could certainly limit the amount of pain and suffering to these people, thinking in their head, well, I don't know that Hanna caused them any pain and suffering, or if they did, it wasn't as much, so on and so forth. And that's, and so it's the prejudice between us, because they could find it either way.
And I want to make sure, which question are we focusing on?
So it's a
It's the
problem
damages.
for the damages.
Damages.
You know, we're not arguing the joint civil liability, but yesterday it occurred to me that due to some of the things Mr. Savaggio said, his testimony is going to prejudice us. I think it's fair for me to argue that his testimony did not go well, and that it went to, I'm not joking, I mean, it went to an extreme that his testimony is going to prejudice real water, and the jury may decide that he is not truthful. And having us tied to him in a verdict is problematic. I mean, we had you know, I don't want to hit this too hard, but we had a breach of the baby case. We had a real issue here, and that's not joint civil liability, that is beyond, that is prejudice. And that's going to apply to Botis, Belsky, Arnone.
Beatty versus Thomas.
Cases. He said he didn't have any other lawsuits.
Yeah,
Oh.
Beatty versus
Yeah.
Thomas, yeah.
Oh,
my
yeah,
God.
that was, okay.
So we have a problem, not of real water's creation, and not applicable, it has nothing to do with joint and several. It has to do with a witness who took the stand and said some things that were not credible for reasons that may be even beyond his control. But that's the reality. And that's the prejudice.
Real water?
Maybe he would have testified better.
Well, I think when that happened, the first case that jumped in my mind was Gunderson, right? What do I do? Did I ask something like that?
You did, John.
How about this, back to the issue
Yeah.
here? So what I did put, if you check yes to either 2F or 2G, whatever it was, the ones that Gallagher and Haley, I just thought that was really, too much to ask the jury to, why are we doing 2G and 2H, How about if we just say, if you check yes to either 2 or 4 in general, without specifying the subpart, would that work?
Well, wait, would there really be a difference? I mean, what you're concerned about is a damages award to get to Haley or Gallagher, which they dismiss their claims against.
Yeah, that's concern number one. I agree with
Don't
that.
you have the same problem on the other side?
I think the other 5, it's the prejudice. We
But that's,
bargained for strict liability. That's Nevada law.
Okay, but
We
let's-
didn't bargain
let's-
for a witness
stop.
going off the reservation.
So on these two, you wouldn't have a problem with the way it is right now?
It's actually 4, right? Because it's the,
Orion and his 2 parents.
yeah, Orion, Camille, Brian, and Keith.
Right, and, yeah, those 4.
So, but wait a second, Your Honor, when I looked at this the first time, and then the second time, I think I'm on the third iteration,
Right.
with this.
You still have, you said last Saturdays there.
No, I didn't know.
Oh, okay.
My first concern was, you want this over?
Yeah, I'm not sure if you'll always
Okay, so my first concern, Your Honor, was whether or not having one number would prove to be problematic for the defendants, because quite often I'm on that side of the room, and they would want their own, they'd like to know their percentage of responsibility.
The portion.
Originally I had
But
8.
when you look at the question simply is saying, give me a number. It's not asking them to apportion among the defendants.
I didn't like that because I
So-
thought it was,
I agree. It's problematic.
yeah, right, so that's why I went back to.
Sorry.
That's all right,
Yeah.
do your sidebar. So, Your
I
Honor,
understand what you're saying, Mr. Parker.
yeah, and
Let's
so-
say fill in give us an amount.
that's right. And so it doesn't matter what defendant you're looking at. You're simply trying to, as a juror, trying to figure out what is the amount for this form of damage, which is not the prejudice that Joel is worrying about, Mr. Odou is worrying about, will be figured out and dealt with on the punitive side, if the punitive box is checked. That's where that prejudice will play out. So if they don't feel that your clients are liars and you weren't as bad as perhaps Milwaukee and Hanna, your punitive amount, if you were assessed with one, wouldn't be as high. If they felt that Hanna's witness was not forthright, not truthful, and did things that were outside and beyond the industry standard for a meter manufacturer or distributor, then their numbers will be higher on the punitive side. But the number in terms of items 12 through 23, it does not present itself as an opportunity to apportion. It's just a number based on damages.
Up until yesterday, I would have agreed with you, but I think 16 through, whatever the end of the, 16 through 22, the problem is, we will never know why the jury reached that number. We'll know that the jury awards compensatory damages of, pick a number, $20 million for one of the plaintiffs.
Okay.
That's a little more than I was hoping for, but.
Let's say.
Let's just ride it.
Let's just for the sake.
Let's just go with
It's
that.
less
That
than
sounds
$2
good.
billion.
All right.
It's less than $1 billion. Let's just say that the jury is really angry. And they decide for Mr. Bottis, we're gonna give him a very large verdict for compensatory damages. We will never know if that verdict is because he didn't like Carl Savaggio's testimony. We will just know that they were angry and they gave a really large number.
but respectfully, that's not true. We will know because the jury is being instructed, and the presumption is they're following the instructions. They're told, this is how you determine pain and suffering. Don't exercise prejudice or sympathy when you're coming up with the number, but just based on what you think the evidence shows. I mean, that's the problem in every case is, you know, we don't break down the numbers to say, well, I'm giving this much because I really didn't like Carl Savaggio's testimony. I mean, there's no other way to handle it. You just rely on the jury instructions, which are appropriate.
We do have a passion and prejudice one that we can beef up a little bit if you want.
But again, those arguments all assume that Mr. Savaggio followed the law and testified under the law. Instead,
I mean, look at me, I mean.
I'm not, I'm just arguing
He
that way.
doesn't want to look at Scott right now.
No, you know, it's Scott's problem to deal with, but it's the prejudice on real water that I'm trying to figure out. Do we need an instruction? I don't know, but we will never know what drove a compensatory verdict if it's out of the ordinary. All we will know is, you know, you guys will be pleased, it's a big number, and we will look at that and go, well, obviously the jury did not like Mr. Savaggio, and now we're off on appeal.
But your
And
position.
I just want to avoid that issue, I'm sorry, Teddy, I just
No,
want
I'm sorry.
to resolve that issue somehow.
Well, the only way to resolve it is to beef up the passion and prejudice.
But the predicate of your position is based upon the jury actually giving a number for compensatory damages based upon the untruthfulness of a witness, where those to me are two separate ideas, two separate issues. The value of a broken leg is not going to be changed by someone lying about how that broken leg occurred. It will have something to do with the punitives or exemplary damages, but I don't think it has anything to do with the compensatory damages or the pain and suffering.
I don't know that you can say that. I think the value of a broken leg could be higher.
Because
If
someone
the
lied about it.
jury, if the person who broke their leg comes off as
A scumbag.
It depends on,
despicable.
But-
it depends on the character and nature of that individual or entity that caused the harm.
Yeah,
It could also be the character and nature of the plaintiff. I mean, those are just realities that we deal with in every case, and that's why you instruct the jury that you've got to award a number that's reasonable and fair to compensate the plaintiff for their injury based on these factors, and you do so without the influence of sympathy. And what the law clearly says is we instruct the jury and we trust that they're following the jury instructions. There's no way to, you can't assume that they're going to ignore the instructions that are given and try to go off that assumption. It's just,
well, but sorry to interrupt, I didn't mean to.
No.
One of the instructions is when the jury is evaluating the credibility of a witness, they can find that witness is completely not credible. They can find that witness is a liar.
And I think that goes to liability more so than it does to damages. For example,
How will we
past
know?
it, let's
Go
just
ahead.
address one of the questions. It says, fill in the amount of damages for plaintiff Keith Haley for past and future physical and mental pain. Now, do you think that this guy lying on the stand affects his past or future medical claim?
Medical claim or pain?
Mental pain.
Mental
Pain
pain,
and
it
suffering.
could. Yes.
You would agree with me?
Tees had to listen to that.
Yeah.
Well, how about the ones that didn't hear him lie?
But you know, again,
Watch it on,
it's, I guess the difference is, you know, in strict products liability, you know, the company lives and dies by their own witnesses, right? Here, it's not our strict liability and it's not our person that took the stand and said some things that, in our view, were not credible.
Right.
And that is going to drive, in our view, the award for mental pain, suffering, anguish. Those are things where they're fairly subjective.
I think
And the jury's gonna look at the witnesses and they're gonna go, you know, maybe I liked Blaine, maybe I didn't like Blaine, but I sure didn't like that other guy. And Powell. And then we don't know, when we go to appeal, or if somebody goes to appeal, not me, somebody decides, hey, I want to appeal, now we don't know what caused that, in their view, out of the ordinary number. And I don't know how we resolve that.
And so I agree with Mr. Odou when it comes to the punitives, but there's a vehicle for them to assess responsibility for the lack of credibility of the Hanna employee, president or vice president, whatever he wants to call himself. There's a way for the jury to handle that. I don't think it's directly relatable to past mental pain, anxiety, anguish, disability, and permanent injury. I think those are separate issues. And I will agree with you if, in terms of liability, that someone not being credible can affect the jury's decision on liability. But again, I think that determination and punitives go more to the credibility and the way someone comes off in front of the jury, in my opinion.
Yeah, and here we have conceded liability, so the only issue for us is damages, and for us, the concern is somebody who is not our employee, not with our company, not even in the same business as us, is their conduct before the court going to impact what we have to pay in compensatory damages? And I think because compensatory damages are so, difficult to calculate, I think the answer is going to be yes. I think you're going to get a juror, I think you're going to get jurors who did not like him. And yes, they can send a message in the punitive damages phase, but they can also do it in the compensatory damages phase, and we will never be able to pick out the old spaghetti from new spaghetti or whatever.
So
euphemism you want.
let me say this to you on that point, Joel, or Mr. Odou. When we came up to the bench on a sidebar, when this issue first presented itself, I thought about kicking that door, because the door was wide open, and I thought about how I should go through it. And, I think that I tempered myself during my cross-examination of him, and that I had questions lined up to go through that door. But I thought about the impact of going through that door and how it could affect this case at large, and would that create even a bigger appealable issue? And I restrained myself and decided, something? This guy is such a bad witness, I don't need to go through that door and ask those questions. So I didn't want to highlight that question that Mr. Rasmussen asked him. And I'm glad I didn't, because I wanted to. You probably could tell by my temperament at the bench. I wanted to go through, and there were some questions I intended to ask, which would have blown, in my opinion, the door off the hinges.
Actually, I stopped it.
But I let it go. My point to you, and you still have the opportunity to question him as well. And I would give you the same advice I gave myself. Is that too dangerous of a line of questioning to start, given the mistake that was made during direct examination? The other thing is, you have the ability under Rule 15B1 to amend your complaint if you want to add cross claims against Hanna right now. Certainly, they've drawn a line in the sand between your client's actions. They've also spent, I don't know how much time, talking about your facility and the problems with your facility and your inability to read their warnings and their instructions. Perhaps this is the time you bring your cross claim or your counterclaim, your cross claim against Hanna and Milwaukee. The point is, there's other ways of dealing with it, and even post-trial, you can do an indemnity action or a contribution action, given what has happened.
Or a cross-claim for breach of liability deal.
Right, so there are ways. I thought about, I will tell you, and that's true. Mr. Kemp tempered me after I had my line of questioning ready to go.
Tempered's not really the right word, but go ahead.
But there are ways you can deal with it. And I do not suggest asking questions that will make more of an issue when you get a chance to cross.
Judge, I think the only thing we can do is beef up the passion and prejudice instruction. That's really the only thing we can do.
I agree that is something that needs to be done, but I think, again, real water cross-examining a witness who has been impeached more than 7 times on the stand just links us to that witness. And that's more prejudice. I think it's more prejudicial for us to cross-examine him further and appear to be in alignment with the things that he has said, which we are clearly not in alignment with. And I think it's very important to be truthful to the jury. And we've tried really hard to be truthful to this jury, and that witness has done the opposite in our view, in our opinion. And again, not necessarily to his fault, but he is a grown-up. He took the stand, he raised his right hand, and he said some things that were ill-advised.
This is why you never put a CEO on the stand in a trial.
Are you asking for an instruction, asking for apportionment of responsibility, Joel?
We can't do that under strict products liability. I'm saying that this is a problem that has been created, that there's not an adequate remedy.
Well, we were gonna ask for a jury instruction asking too, so.
I can do that.
You can't do that in the strict product line.
Okay.
There are two products, that's how you do it.
Hmm.
I don't even know if it's correct now after this discussion, but there are two products. We're not going up and down the chain of distribution anymore. We're going sideways. It's not a chain, it's a spider web. And that's not that does not serve the public policy that strict product liability is based on. It's based on the idea that you hold a manufacturer and distributor and seller of the same product. So it's not, I just asked, possibly, maybe that's what you'd like to do. I think there's a basis in the law for it. I prepared argument for it. I don't know if this is the correct place to do it, but I'd like to make a record and say we asked for an allocation between the two defective products that are contained in the complaint. They're not one product, they're two.
That just flies in the face of concurrent cause, number one. And number two, if there's supposed to be an evening of the balance between the two defendants, that's what contribution indemnity is for. That's what the court of equity is supposed to determine. And that's where this argument really should be made, I think.
Isn't it also possible that after we get done with this, certainly either side could file an indemnity or contribution claim against the other side?
Right.
Maybe that's.
I said that a second ago.
I know that, and that's what I'm trying to say, is that maybe that be, as opposed to, we can certainly beef up the one, but with regard to that, that's the only remedy that I can see that would probably work out.
The only other thing we mentioned, and I don't know how, if this is something that Mr. Odou thought about, but there should be some, at a very minimum, some kind of curative instruction on that question. Because that was an improper question, and it was rushed, and the answer was rushed before we could say anything. We did our best not to bring further light to it until we got to the sidebar. But I think there has to be some kind of curative instruction on that issue. And maybe that at least
I
takes
think
care
that's
of
a
it.
Gunderson, right? I said
Mhm.
that
Yep.
yesterday.
That's right.
I haven't read it in a while, but typically this would be the time to offer something like that.
So if Joel, you have something, Eric was talking about it
Certainly.
yesterday, you can,
We'll give it some thought
Give that
as
some thought.
to how to cure it. Again, I think it's more mitigation. I don't think there is a cure. Again, our trial has been, and our strategy has been that we admitted liability, we accepted responsibility. We have done our very best to tell the jury the truth. And then a witness takes a stand for a co-defendant and is impeached more than 7 times. And does not appear to be truthful. And I think that's gonna reflect and cause prejudice to our defense. And, if it had gotten worse, we would have had to find some other drastic remedy. He's still on the stand. And I hope it does not get worse. And I hope we don't see that from other future witnesses. We've gotten pretty far down along in this trial. I'd like to get it to the end without any further, I will say, mishaps. But I think this is extreme prejudice. I really do, and that's not just an argument. This is a witness taking the stand and saying things that are just completely unfortunate.
I would also point out, Your Honor, that he basically accused my client of putting poison in the water. And in the course of all his other statements, he kind of threw us under the bus, and with no real evidence. I mean, the only way he could have gotten what he got, unfortunately, is from Mr. Rasmussen. And, that's his client's problem. And I'm not saying, but, he sat there and basically said we poison people. And it implied that we put it in the water. And this is, I think, like Mr. Odou said, You know, we've been trying to be truthful, and we feel like plaintiffs have been pretty good about this too. Like plaintiffs haven't accused us of putting poison in the water or anything here. So, you know, I agree, I think we have a big problem.
Judge, can we finish the verdict form perhaps?
Yeah, I mean, you know, we went off on a philosophic discussion. I don't know what the answer is. My mind is very much open. If someone wants to tender tomorrow a curative instruction, please feel free to do that. We'll discuss it on the record and so on. But I thought it was interesting to sitting back listening to everyone's perspective.
Okay, Judge, where we started this discussion was on question number 12 on page 4, and I've given you to review my proposals, comments.
Is that on page 5?
Page 4, top.
Yeah, top of page 4.
Oh, okay, I see. I've changed the number.
Right, Judge, and I just think that's the best way to handle it, just to have them fill it out. I showed you my previous draft where I said if you answer a question, blah, 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 yes. You know, you do that too. I just thought getting into the 3 subparts was really not the way it goes.
And I do agree in this regard because, you know, it's been my experience with juries. You want to keep the questions that set forth in the verdict form, the special interrogatories or whatever. It has to be extremely simple and straightforward. And there's a reason for it, is you don't want to create confusion. Because even lawyers get confused from time to time. They do. And gotta make it simple. And,
Yeah, Judge, subject to that issue, whether we're going to say if you find yes or no, is there anything else?
Yeah, the last item is the concern that the jury may not understand that there is a court order summary judgment that the medical bills are reasonable and are part of either this verdict that they're filling out
oh, I see what you're saying.
or will be subject to a post-trial.
I thought we were put that in the jury instruction, the court has already.
It's in an instruction. The question, the concern I have is for real water, when the jury fills this out and they hear like Orion Gallagher has $200,000 in medical bills, they go, okay, well, we start at 200,000 and go from there. I know it says, I know it doesn't say medical bills here.
That's the reason I put past and future. That's why I outlined the thing to get away from that kind of concern.
And the instructions will clarify, these amounts have been determined by the court.
Maybe I should have the verdict now. Maybe, do you have a problem with that?
Well, if you put it in the verdict form,
Well, how do you get it from the co-defendants too? That's the other part, I'm sorry. I interrupted.
well, see, if you put it in the verdict form, that kind of prejudices the co-defendant's liability defense, doesn't it?
Yeah.
That's why I didn't want to put it in the verdict form.
So,
But they get it based on the finding of
I don't mind,
liability.
I don't mind beefing up that section of the instruction saying, the court's already determined this, and this is why it is not on the verdict, you know, something.
Yeah.
Yeah, we could do something like
I
that.
think something like that would be fine.
Okay.
The only hiccup I would see to that is, let's say, like Orion Gallagher's a perfect example. He's got $200,000 in past medical bills.
Right.
We've settled that claim, so you're seeking those bills presumably from the remaining parties. So how do you?
Well, that's why you just leave the line on Orion Gallagher, and you don't get into this mess, see?
Yeah.
That's-
But then do they-
You're talking about after the fact.
There's one, yeah.
I
that's
don't,
the thing.
but for the other ones I do.
Yeah.
So regardless of what the jury puts in this verdict form against real water, the judgment entered on the jury's verdict against real water will not include any damages for Orion Gallagher or Keith Haley, or the Gallagher family and Keith Haley because of the settlements.
Right.
So it really doesn't affect real water at all if they put a value for damages for the Gallagher family, because that's not going to be entered as a judgment against real water based on the release.
Right.
If the way that it works is there's the judgment will be entered. There's only one award for each plaintiff or group of plaintiffs, and then the judgment is entered against the appropriate people. So if Milwaukee and Hanna are found liable, the judgment will be against Milwaukee, Hanna, and real water for all the plaintiffs except Orion, Gallagher family, and Keith Haley. If Milwaukee and Hanna are not liable, then the judgment will only be entered against real water for the other 5 groups of plaintiffs, excluding Gallagher and Hidell. So
Okay, let me
That's why
focus on,
I thought it's better in the verdict form just to keep it simple.
let me focus on Mr. Batiste then. The
Okay.
plaintiffs have an objection to 16, where Mr. Batiste said, medical bills, ... to be determined by the court. Future medical costs to be determined by the court. And then the jury knows
They've already been.
they have, or determined by the court, instead of to be.
and you
Has
can,
been, I don't
Isn't that
care.
in the jury instruction already?
It is, but I don't want it to, again, there's
Now
a,
you're trying to incorporate jury instructions in the verdict form.
no, I just want the verdict to be very clear that Mr. Batiste is only recovering for these things and not for the things that the court is
you
already.
can emphasize
You
that.
can emphasize that in your closing on when we get the instruction.
You can walk them through the verdict.
I definitely will be walking.
Yeah, yeah.
And you can blow up that instruction.
Right. And that's why I said, if you want to beef up the instruction, I have no problem with
All right, well, I could beef up the instruction.
Yeah, you
that.
can blow it up in front of the
The
jury.
prejudice and the simply one too.
Because one thing for sure, I feel fairly confident that whatever the instructions are, the jury will follow.
I hope so.
Okay, so.
Put enough time on that, right?
Subject to that is everything.
If they don't get it now, they're never gonna get it, Your Honor.
You're right. I agree.
The only thing that's still kind of a dangling thread on the verdict form is future medical damages. If we reach a stipulation, we handle it like past medical damages. If we don't, then we need a line for that.
I think we're gonna reach a step on that.
I think so too. I mean, we talked about a number and, you know, if it's less than that number, I have no objection at all.
Well, after that testimony, I think we should double it, honestly.
That's
Because that is all circular, Your Honor.
So you know what's interesting?
I don't even know the numbers, they've never talked to me about this.
I can say this. This will be back to back where I had, I'll call it fantastic testimony by a witness on the stand. Right, Tori? And here's my point. The jury did not overlook it. I will just leave it at that. They did not overlook it,
That's right.
right? That's it.
Your Honor, we'll keep working on the verdict form. There is a housekeeping matter I wanted to bring to the court's attention. One of the jurors needs to leave tomorrow by 3:45 for a doctor's appointment.
Right, and if we've taken, Mr. Marshall, you've taken that into consideration, I think you told me that, right?
Yes, Your Honor, and that's why Mr. Odou is bringing it up.
Oh, yeah, we'll accommodate.
Yes, Your Honor.
Your Honor, as part of that, just so you know, I know that Mr. Robbins has one of his witnesses that must go tomorrow in the morning. And I have a witness that must go on tomorrow as well. One of my, David Portman must go on tomorrow, he flies out. So, and I'm gonna see what I can do to move him a little bit on his flight, but it's like a 2 o'clock flight, but I'll see what I can do to get him
Now,
out.
that's their morning's expert, and I take my morning's expert in 3 minutes and 41 seconds.
We all know.
He's been bragging about that for a while, Mr. Rasmussen. If you can do it shorter, I appreciate it.
7 minutes we'll give you? How's that?
Oh, Jimmy. I think it depends on who's gonna cross him and how long they're gonna take
I'm gonna
him.
cross them, it'll probably take a little bit on the cross.
We played.
I took
Rock
15
paper,
minutes on
scissors.
my cross, by the way, with it.
Well, you only had 3 minutes and 41 seconds to go.
Just saying, it wasn't the longest one I did.
Right, we should probably put him on right after Hidell then.
And I'm quite sure we'll make that.
I'll do my best.
Yeah, if you want to put him on after Hidell, right, and go back to.
So then the page lines that we've been talking about with the different depositions, which I assume we're getting to be done so that we can play them after that.
Right.
We're gonna do Carl Savaggio after your expert, correct?
No. Carl will be on the thing in the morning.
No, I thought you were gonna finish the, Rob's expert first.
Yeah, I thought we were gonna do Hidell
It
first.
depends if you've only got 20 minutes left with Carl.
I have some too.
So you're
I only have
with Carl.
maybe 10 minutes, but I did have a couple.
So, I thought we accommodate Rob's.
I didn't know that.
Yeah.
Well, I didn't know that. I thought 20 minutes, not a big deal, boom, we're done.
Yeah, just
Why don't
don't
we-
discount Mr.
why don't we try
Odou,
to
he's
get
got a
the-
bone to pick with that guy,
Two
so.
witnesses that we have here in and out, which would be Hidell and Forsbach,
Okay.
and then we'll go back to each Savaggio.
Your Honor, can I just confirm, I asked for an
I have no
abortion
questions.
instruction on the verdict form and.
Yes, you
cited-
can,
Okay, so it's all done, it was declined,
yes.
okay.
And for the record, I just want to make sure I'm clear that I have my challenge as far as just a little bit of housekeeping. I do understand that there is an issue regarding the application of NRS 104.235 and 238 as it pertains to third parties. I don't know if that's been clarified yet or not, based upon the fact that the warranty claim would be as to Milwaukee only, right?
Correct.
So is that an issue for you at this point now?
I'm sorry, it was hard to hear you.
Yeah, it appears to me that the warranty claim would be applicable only to Milwaukee and not your client. Consequently, is that an issue?
No, that is her client.
That is
Oh, you got Milwaukee, okay.
Mr.
I understand.
Rasmussen likes this, she doesn't like it.
I understand, I got you. So I need to look at chapter 104 as it pertains to privity.
Correct.
And Mr. Kemp, I do have your reply brief and also briefing. Which case was it again? Was it?
They were, I think we started, I didn't read that again, Your Honor, I was gonna read it tonight, to be honest, because I thought we were gonna get to this tomorrow, because I thought we were getting testimony today. But in any event, I think there's there's the Mahosco case.
I have it right here. Okay.
Then there's another case called Long, something like that, that's one of the leading cases. And then we had the Kiabani case on the bystander issue, and we also had the Court of Appeals case, the dental implant case.
That was Judge Bullock.
Right, and then I think we did cite two cases from New York, my memory, from back east.
I know it did.
We
I got
had,
you.
one was a class action case by federal judge, and so.
I'll take it.
And I'm not sure, what I heard you say is, it's
104,
104,
2318.
they're right.
Last one is you were gonna give me a ruling today about Laura Brown.
Oh, I'm gonna do it. I'm gonna clean everything up.
Okay.
I just point out that this doesn't end it, they have a right to file a judgment in on this too.
I was trying to avoid that. I mean,
I think they're gonna file it anyway.
should we do that instead?
Judgment of what?
It's 104-2315, 104-2318.
I have them both now, thank you. Just want to make sure. All right. Are there any other dangling issues?
Not that I can think of.
We will work
Other
on,
than the person on land, but.
we will work on cleaning these jury instructions and verdicts up and recirculate.
Okay. Lastly, regarding Ms. Brown, and I thought about it, I don't mind saying it, I struggled with it because I remember Mr. Robbins made a comment, he said, Judge, historically, appearing in front of you, you do feel that cases should be tried on the merits. And that's true. But just as important too, we do have rules in place. What do you do? I mean, you have 16.1, and I understand there's some confusion here, but to me, it appears to be very difficult for any potential cure at this stage of the proceeding. For example, if this issue would have been raised to me regarding Ms. Brown, say, while we were, before we started trial, or maybe even the first week of trial where there could be enough time to have her deposition taken and have a transcript taken, and just as important, maybe motion practice as a result of that over the next day or two, or even argument being made. But right now, her deposition can't even be taken, right? It can't be, there's not enough time. Just as important, we don't even know specifically as to what she's going to testify to. And so what I'm going to do, based upon the way that this disclosure was made, I'm going to exclude her. I just want to say that.
And the interrogatory answers.
Well, yeah, I mean, that too. I mean, there has to be some indication. And I don't mind saying I thought about it, and tough decision, but at the end of the day, that is the decision. And I could see potential, and especially now because we don't have no clue as to what she's going to really testify about. And so, and maybe she would have added something to the case, maybe not, I don't know. But that's my decision. And as far as the issues raised regarding 104-238, 104 2315, and also the cases have been cited. I have all that right in front of me right now. And with that in mind, it's 5 o'clock sharp. Thank you. Thank you.
Tinian. And just as a reminder, I still need plaintiffs, hard copy number 1, the redacted version, and Hannah's 7180.
7180, copy, got it.
I mean, for example, Monday, we're like 5 o'clock Monday. Then Tuesday, I actually, we can have a break by Wednesday.
Well, I was about us meeting my closing argument on Thursday, or I don't think that's today, so.
Yeah, I understand that, but I was,
Yeah, I was.
worst case scenario.
I'm hoping we can go Monday now. That's why I asked.
Oh, yeah, we have all day Monday. Good. We have all day Monday, so.
All rise to the adjourned.
All right, do the parties stipulate to the presence of the jury?
Yes, sir.
Yes, sir. Ladies and gentlemen of the jury, good morning to you.
Good morning.
All right, so we're going to continue our journey as far as this case is concerned. And ma'am, are you doing better? All right, that's good. So anyway, it's my understanding, we have our next witness that's going to be called, is that correct?
Yes, out of order, yeah.
And so, ladies and gentlemen, what we do, and I think you know this, but from time to time we call witnesses out of order based upon availability. Right? And I think you know that. And so it's my understanding that Mr. Robbins is calling his witness, is that correct, sir?
Yes, it should be a short, hopefully a short witness.
All right. You ready to go get him?
Yeah, Milwaukee calls Henry Hidell.
Okay, could you switch over to me? Do you?
Sir, please be cautious as you ascend. Stand and face Madam Clerk and raise your right hand, please.
You do solemnly swear the testimony you are about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God? May I have you state and spell your name for the record?
My name is Henry, Henry, Hidell, Hidell.
Thank you.
Please be cautious as you sit, sir. That's yours on wheels. Thank you.
I feel like I'm amongst the elderly.
Morning.
You may proceed, Mr. Robbins.
Thank you. Good morning, Mr. Hidell. Can you introduce yourself to the jury and why don't we start with your educational background?
Good morning.
Good morning.
My name is Henry Hidell. My education is as undergraduate in geology and hydrogeology. Hydrogeology is the science of water. I often feel like I'm a cardiologist of the earth, because all the streams and the aquifers are what we study. So we're specialists in the science of water. And then I have a graduate degree in urban planning.
Okay. And why don't we go to your real world experience, your professional experience?
For the last 60-some years, the science of water has been the core of my business life. I am the step-down as chairman of the International Bottled Water Association. Been heavily involved in the bottled water and beverage industry. I was vice chairman of that organization. I have built some 100 beverage bottling plants, designed them, design treatment trains, how you treat water that gets potted and used. And
Can I stop you there when you say design and build more than 100 water bottling tanks? What else does that entail? Is that architectural build,
that's
engineering?
from architecture, engineering, treatment systems, and startup and running the bottling. We own bottling plants. I've done a number of formulations for what goes into those bottles. As you all probably have seen in the shelves, there's bottles that have certain health claims, good for calcium. I did one for the elderly called geriatric water, and I drink it regularly. The waters all have a formula, so we have 6 international patents on health formulations for water. On a PCQI, thanks to the federal government, that's all they could call us. It stands for Preventative Controls Qualified Individual. And you take your courses and you are, under that designation, permitted to craft, write health safety plans, food safety plans for food manufacturing. And the reason that's important is bottled water is considered a food. And so we have to treat it as a food. It's very different than your public water supplies, and it has to be handled in a very careful, monitored way. Because the food regulations of the I'm from Massachusetts, of the U.S. government under the FDA requires that all products for human ingestion have to be handled carefully and must not have any components that are not suitable for human ingestion to be present in the water.
And as part of your PCQI qualifications, does that mean you're HACCP certified as well?
Yes.
And as part of your PCQI duties, how many roughly, you're going to give the jury an estimate, how many bottled water plants you've inspected over the years? Roughly.
Well, over 60 years, something over 1,000, all around the world. We're a global company. We're not just in the U.S., but Latin America, Africa, India, Asia, Europe, China. I guess China's part of Asia, actually. So that's what we've done.
Can you give a jury just a sampling of some of the companies you work with that they might recognize?
Well, you'd recognize Nestle. They were at one time the world's largest bottled water purveyor. You would know Danone, the yogurt company. Well, they own AVA, and they've done a lot of bottled water. Pepsi and Coke, everybody knows. Everywhere in the world, not just in this corporate.
How about Fiji?
Fiji, yes.
Voss?
Voss, yes.
Monster?
Monster.
Let's finish up. What is the member of World Food Sciences? You're a member of the World Food Sciences and Technology.
When we do the kind of research we do, we need various third-party scientific entities to do our testing. And GFTC, the World Food Science Technology Center, which is located in a town north of Toronto, Canada, is one of the world's leading food science testing labs. And there, when you do products with ingredients in them, like a beverage, like calcium or collagen, you need to make sure that the product is doing what you claim it's doing. In other words, if you have X parts of calcium in that solution, they will confirm that it's there. They did a lot of shelf life, or do a lot of shelf life study. Many of the product, the due dates, do not buy this after X. They do a lot of that kind of testing. And so for the products we put together, we want to know what the shelf life is. We need to know that helps you manage inventory, because if you make it too soon, it will exceed its shelf life on the shelf before it's picked up. If you make it too late, it's already exceeded its shelf life, so there's a balance between shelf life and retail shelves.
Okay. And then lastly, you're a member of the International Society of Beverage Technologists. What's that?
That was started many, many years ago when I first started in this business. It is a group of beverage scientists who have come together, and most of them come out of the soft drink industry, Cokes and Pepsis and national beverage and groups like that. So they're mostly oriented toward the carbonated soft drinks. As that industry started to move into the bottled water industry, such as Pepsi with its Aquafina and Coke with its Dasani, then they brought in water experts. And so I was brought in as one of the water experts, and so I've been along coming in. Not that they didn't understand that their product had 99% water. They were more interested in carbonation and syrup.
Okay. And you were asked by my office to do an investigation regarding this case, correct?
That is correct.
Can you explain to the jury just generally what you ended up investigating?
Yes, so I was asked to come out and, in a sense, inspect the plants that were used by Real Water. And the first one I inspected was in Mesa, Arizona. And the second one I inspected was here in Henderson.
Henderson where?
Nevada.
Oh,
I didn't do that right, did I?
Get it. Okay.
It's a speech defect from Boston, okay? It's nothing I can help with.
We'll forgive you. We've had okay, and I'm sorry, didn't mean to cut you off. What else?
So what I had to do during the inspection, when you were in a situation such as Real Water was, you as an inspector, I wanted to look at what their facilities were generally like, whether they were clean, whether they had on-site laboratories, or how they monitored and managed the quality control, quality assurance of their product, called QC/QA. And in general, look at the equipment they were using, whether it was appropriate for the product being made, look at how they stored their raw materials, look how they stored their finished goods, and generally just get an idea of how they operated their business and whether they had the appropriate equipment. That's,
how about on-site laboratory?
well, we like to see, in the bottled water industry, you should do very fundamental testing every day in the process of what you're doing. In other words, does it meet your standards? Does it have the right pH? Does it have the right conductivity? These are all measured. Temperatures are measured. And so you would have a lab that would do that. If you had a product that was prone to potential microbiological contamination, like let's say mold, which is a very common, everybody's familiar with mold, you would have a lab there that would have incubators and petri dishes. You almost know what petri dishes look like from high school. And so you would put a biological sample in there and you would incubate it for 48 hours and see if you could grow anything. And sometimes those are necessary. I did not see any incubators or that type of lab equipment at that facility.
Okay, and what is blending mineral ingredients? Did you do any investigation regarding that?
Yes, so one of the keys when you start blending minerals, or any ingredient for that matter, flavor, sugars, into a liquid matrix of water, the key that you have to make sure is it is distributed through the entire, let's say, tank evenly. And so in this case where they were adding minerals to the water. I was looking at their blending process to see how they did it. And there are a number of ways you can do blending. The typical ways in a bottled water facility for doing blending is you have three ways typically used. And that's just like making an alkaline water like Alkaline 88 or Ascension. You've probably seen those on the grocery shelf. You can, typically what is used in the smaller plants is a tall 4-foot cylinder, probably 2 feet wide, that has crushed limestone in it, magnesium flakes. And what happens is when the water runs through that, the pH of that water will rise, which is what you're looking for. And typically when it comes out of that filter under natural conditions, natural flow, the transition is very fast to raise the pH. And you'll end up with a pH of 8, 8.5, maybe as high as 9. Depends on the flow rate in the filter. That's a very natural way to do it. Many of the smaller bottlers in urban areas use that. They process their water through reverse osmosis. I don't know whether you've heard that term or not. So cleans the water up, so you can use any water through it. And then you put it through several filters, and then you put it through this contact tank. And so forth. And it's a very natural, very easy way to increase your pH. Remember, you want some consumers want alkaline water, and that's one way to get it. The other way is to, when you have large batches and you're using batch technology, which means you make a 6,000 gallon or 10,000 gallon tank of this product, and then you run it through your fillers. You have to pour these ingredients into the top of the tank or feed them in, or you would do it. And then you would blend them in that tank. And typically in that tank, let's say it's a 10,000 gallon tank, which isn't a big tank, by the way, you would have a paddle system. So there would be an electric motor at the top of the tank. Usually it's put in at an angle, and you have a paddle at the bottom and maybe a paddle midway up, like a ceiling fan. Only it's just moving something slightly denser than air, water. And you would run that for a very specific period of time in order to get those minerals in solution in that water. And then you would test that by a conductivity probe, which generally gives you an indication of what the mineralization of that water is. And temperature plays a role in the solution of these minerals. So you need to know the temperature of the water, what the solution has in it, and how long to run it. Sometimes you have to run it for 3 or 4 hours. Sometimes with sugars you can run it a few minutes and you're using simple syrup. The other way that is also very common in the industry is you make a slurry. What I mean by a slurry, kind of a muddy water density. And in that muddy water, you have all these minerals. And you've prepared that so that those minerals are evenly distributed through that slurry. And then you have what we call a dosing pump, which pumps that thick liquid into a flowing line. So if you have a water line that's going from over here of treated water and it's going to the filler where you all are sitting, then somewhere in between there, you will inject this slurry, and it will be tied to the flow rate through the pipe. and it'll come in what we call a venturi feed. In other words, when water goes through a pipe, it creates a vacuum on the side wall of the pipe, and this is hydraulics. And that vacuum will cause that slurry to go right into the solution, and it's fed through the venturi will kind of spread it out in that flow. That doesn't finish it because you have to get it in solution. And typically after that, you will have a long pipe. It could be 5 feet long, it could be 2 feet long. It depends on what you're trying to dissolve in the water. And inside that pipe are a number of curvatures of stainless steel with fairly sharp edges. And it creates huge turbulence. The turbulence is highly calculated. So by the time it comes out the other end of that pipe, it is in full solution. And again, you're going to record the pH, the conductivity, the temperature to make sure the solution is performing the way it should, and then it goes directly into the filler. That's the way it's done. It's a well-developed science.
Okay, so, so I can understand it, that essentially there's two systems you use, the fan blade at the bottom of the tank, or a smaller injectable tube where you mix it up in a smaller area. Okay. And in your inspection of the real water facilities, were they using either of those processes and done the,
I saw nothing that would indicate they were using those processes.
okay.
We have an objection, may we approach?
Yes, one day.